Good morning, everyone. This is the second chapter of the legal and regulatory aspects of the banking. I have already uploaded the chapter 1. From this chapter, I will upload two part. That is part A. It consists of the understanding of the topics, and the part B it contains the questions that could be asked, the important questions I will discuss in the part B. So one in which we saw that who control the banking system in our country, and in this chapter the topic name is the control over organization of the banks. This chapter will deal with how they can be controlled. So how the banking will be controlled? It will be controlled through the rules and the regulation and the acts. So why these rules and the regulations and the acts is required? First of all, I will differentiate what is rules and what is regulation. Rules and regulation. Simply, the rules is made by the central government and the regulation is made by the Reserve Bank or the particular organization. So the question is why these rules and the regulation is required. The rules and regulation is required mainly for the purpose of controlling the banking system in our country. Why it is required to control the banking system in our country? Because it's very closely related with the public, and if something happens to the bank, then it will directly or indirectly impact the public of our country, because it's a deposit that is being done in the banking system, and that deposit is circulated around the economy of our country. So it's very much required to have the rules and the regulations to control the banking system in our country. So where these rules and regulations are applied, where these power are exercised, it's being exercised in granting of the licenses or the paid up capital that is required to start the business of the banking, and the shareholding rights that who will hold how much shares and maximum amount of permissible shares that one can have is all will be discussed in this chapter. The first topic in this chapter is the licensing of the banking companies. The Banking Regulation Act defines the licensing for the commencement of the business in the banking system in India. Licensing system. Why this licensing system is required? I say if there would be no licensing system, then every now and then in every corner you will see the bank, and since the bank has the deposits of the public, it's very much required to regulate or to have the licensing system, so that indiscriminate amount of banking banks could not be opened. So licensing under section 22, the license is granted for the commencement. It's not that the once you get license it's all over, but you have to maintain the financial health or the shareholding or the conditions that is being written under section 11. You have to comply all these conditions in order to maintain the licenses every year. So if some inspection is being done, and that the RBI did not find that the health of the bank is well enough, or they are complying the conditions which is mentioned in the section 11 or section 22, then they can take an actions and cancel the license of that bank. So inspection of the RBI, it's very important to write this section, so that because the question could be asked in this part, that and on which section the inspection is allowed to the RBI to check the health of the banking of the particular bank. It's section 35. Section 35 gives the power to the RBI for the inspection. So the condition of the licensing, the conditions that the particular bank has to follow is mentioned in the section 11, and there are also some additional conditions banks for only few of the banks which is mentioned in the section 22. For foreign banks, the conditions for the licensing is out and out same, but it has to follow the additional 3 requirements, which is as follows: like they have to work for the public interest first, then second, the law of the country in which they are being incorporated, the law of that country is in sync with the Indian law, and the third, the memorandum of their particular company, the memorandum of association or memorandum of understanding that is required in opening of any company in the world, it must be synced with the Banking Regulation Act. And there is one concept in this particular, there's one concept of the local area bank. What is local area bank? It's not a separate bank, any bank which is very much active in particular space, particular geographical area, so that it can advise other banks to follow something or to promote the banking system in that particular area. The local area bank is required or in operation. So the licensing can be cancelled under section 22 part 4. And what are the grounds of the cancellation of the license? Is cease to carry the banking businesses. Let's say the one bank got license to do the banking business and they are involved in some other process, some other business, then their license could be cancelled. And the grounds for the cancellation of the licenses is also mentioned in the section 22 part 1 and section 22 part 3. If they are not complied these two sections, then their license can be cancelled. And what if the license got cancelled? Is there any provisions to make an appeal? Because in some cases these licenses, the banks are not found guilty. So where they can appeal? They can appeal to the central government within 30 days. Mind this, you have to write this. This question could be asked that within 30 days they have to appeal to the central government about the cancellation of the license. This chapter is branch licensing. Even if some particular bank has to open its branch or shift the branch, they have to obtain a license, and the licensing is not request and just granted. It's not like that. You have to make a list of what all branches you are going to open in the year, and you have to give a request for that opening of the branches or the shifting of the branches or the ATM opening once in a year to the RBI. And if RBI granted this, then you can open furtherwise. And as we said before, granting of the licenses, the banks, the RBI will see some of the things like the financial condition of the bank, the management of the bank, the capital structures of the bank, or the public, or they are working in the public interest or not. All these can be seen. And which section gives the RBI to check all these things? It's under section 35 Banking Regulation Act. And we have seen like the commercialized bank or private banks are the license are directly given to the Reserve Bank of India, the license request directly given to the Reserve Bank of India. But in case of the regional rural banks, it is routed through NABARD. First they have to give to the NABARD, and then NABARD forward it to the Reserve Bank of India for the granting of the next topic is the paid up capital and the reserves. For opening any bank, the paid up capital and the reserves plays a very important role, because as we know that bank is a kind of public company, so the shares can be allocated. So the paid up capital and the reserves plays a very important role in the banking system. And there are also some conditions that they have to follow in order to open the bank. So the conditions are different for the foreign banks and the Indian banks. First we will see the foreign banks, then we will see the Indian banks. In the foreign banks, the deposits with the RBI is at least 15 lakh. They have to keep the deposit with the RBI, plus 20% of the year-wise profit they have to keep with the Reserve Bank of India. And if the offices are in Kolkata or Mumbai, then they have to deposit 20 lakh with the RBI plus 20% of the year-wise profit to the Reserve Bank of India. And on which section these things are written? It is written in the section 11 part 2. And for the Indian banks, it's a section 11 Part 3, condition of the deposit is 5 lakh and 10 lakh respectively. And there are also some more conditions to the Indian banks, condition or options you can say, that if the bank is opening and they have to deposit only 1 lakh, and with every branch they open they have to deposit 10,000 with each branch they open, and overall the limit of 5 lakh should not be exceeded. And if the bank is only in one place, there is only one place there, one bank is there, then they have to deposit only 50,000. And if the Indian bank is only in Maharashtra or Bengal, that is in Mumbai or Kolkata, then they have to deposit 5 lakh and 25,000 with each branch they will open capital. So there is one conditions with regard to this, that your paid up capital must be at least half of the subscribed capital, and subscribed capital must be at least half of the authorized capital. And where this has been mentioned, this is mentioned in the section 12 of the Banking Regulation Act. The next topic is shareholding in the banking company. The shareholding in the banking company, there are some conditions like voting rights of the shareholders is maximum 10%. It doesn't matter how much shares they hold, but the voting rights should not exceed 10%. And if they want to transfer their shares the transfer of the shares is more than 5%, then they have to take the permission of the Reserve Bank of India. And the maximum commission charged by the brokers in the transfer, or say in the share market, then it is only 2.5% of the issued price. And dividend only, and the dividend could only be given when all the expenses are written off, that all expenses they have already paid, then only the dividend can be calculated and paid to the public. The next topic is subsidiary of the banking company. The bank can have their subsidiary, and the maximum shares they can avail from that company is 30%. The next is board of director. The next topic is board of director. What is board of director? The board of director are the group of people which runs the company. So banking system is also run by the board of directors, and this board of directors, and it's mentioned in the section 10 part A of the Banking Regulation Act to have the board of directors. And the one main conditions of having this board of directors, that 51% of the people, that is more than half, should have some special knowledge in accountancy, agriculture businesses, rural economy, then banking, cooperative sector, economics, finance, law, etc. These are the special knowledge. And the maximum of the board of directors could maximum be appointed maximum for 8 years, and once they are removed they are not eligible to get appointed for 4 years. Likewise, board of director, the next topic is the chairman. The chairman is appointed under section 10B, and MD is appointed under section 10B, and their maximum tenure is 5 years. And what is the work of the chairman and the MD? The chairman is responsible for the management of the company. The MD is also for the same, and MD takes the charge of the chairman if the chairman is absent in the particular company. And what is their qualification? Their qualification is same as required for the board of directors. The special qualification that is required I already have mentioned. And and the RBI has the power to remove them, and if RBI has removed them, there is no options of any appeal to any places. This question could be asked from in the certification exam, that whether they can appeal or not if some chairman or MD got removed. The answer is no. And what if some chairman or MD is not there? Let's say both are fall ill, they have resigned or something, then there can be a temporary arrangement which is maximum for the 4 months only. Power of the Reserve Bank of India. It's under section 10BB to appoint chairman. Under section 10BB, the chairman is appointed, and 10B the MD is appointed, and 10A the director is appointed. And RBI also exercise some extra power, like appointment of the additional director if they think so that is required. For example, in ILFS case recently, the RBI has appointed the directors or supersede the directors of the main ILFS and appointed the additional directors and the main directors of the company. So additional directors appointed under section 36 AB, and for maximum 3 years, not more than that. And the RBI has also the power to control over the management via removal of the chairman. Under section 36 AA, they can remove any important personal key positions in the banking system, or if someone is not happy, if some chairman is removed, like Chanda Kochar has been removed by the RBI, then she can appeal to the central government that I have been removed, I should be heard, like that. And if RBI has given an instructions to remove someone, and if he is not leaving his positions, then there is a provision of fine of rupees 250 per day. The fine is contravened. And according to the section 36 ACA, the superseding of the board could also be done by the Reserve Bank of India. This is what happened in the ILFS case. The next topic is corporate governance. In every corner of the world, the concept of corporate governance is being promoted. Reason being, it's a very transparent. The management is very good in the corporate governance. The responsibility, the fit and proper criteria that comes with the corporate governance is being applied. And there is one principle, it's very famous in the corporate governance, OECD principle 2004. I will give you one task to see the full form of OECD. It could be asked in the exam. Just search the OECD and comment in the section, so that I could also see that how many people are very much interested in all these things. So this corporate governance is being implemented in the bank. First, the RBI has implemented the fit and proper criteria, adopted the fit and proper criteria on 25 June 2004, and this fit and proper criteria is appointed everywhere, like to have to the shareholders, to the directors, to MD and chairman, etc. Everywhere it's being implemented or adopted. And corporate governance in bank, there is also one very good point that you should keep in mind, that after the implementation of the corporate governance, the nepotism or the nepotism got ended, equality being promoted, the more transparency is there in the system, and this also put some of the very good decisions by the Reserve Bank of India, like in any banking system there should not be more than one family member in the board of directors. Likewise, previously in any board of directors, any number of family members or only the family member runs that businesses. Now it is not allowed. If it's a public company, then they have to comply this condition, like there should not be any more than one family member in the board of directors. Thank you. If you want to suggest something, I will welcome that. I will improve on that, and I will come strongly. Thank you.